Hello and welcome to this webinar on admissions of liability, so top tips for personal injury lawyers. I'm Richard Biggs, I'm a partner at Irwin Mitchell. I've been with the business for 12 years. I've been specialising in serious injury cases for over 20 years, acting for seriously injured claimants. Now, we're going to talk today about admissions of liability, but specifically what to do when faced with an application by a defendant to withdraw an admission of liability that's been made earlier in the proceedings, whether that's pre-issue of proceedings or even post-issue of proceedings. So we're going to have a look at top tips. What do we do when faced with such an application, and how does such an application work? So today we're going to cover Civil Procedure Rules, parts 14.1 specifically, and Practice Direction 7 to part 14, which are really key in admissions of liability and applications to withdraw. We're going to look in particular at the court's considerations when faced with such an application to withdraw an admission of liability, and that is set out very prescriptively in 7 criteria in Practice Direction 7, so we're going to look at that carefully. And what do we do when faced with an application to withdraw? So it's a heart-sinking moment when you think you're home and dry on a case with an admission of liability, and suddenly an application to withdraw lands on your desk or by email. What do we do then? And we're going to look at practical steps, really, top tips to respond to these applications. Now, we are in a different position than we were some years ago. So a case called